I'm Apurva Mandhani, and this is the Print's Page Turner. I have with me today Rajya Sabha MP and Senior Advocate Dr. Abhishek Manu Singhvi to discuss his new book, From the Trenches, in which Dr. Singhvi talks about some of his most interesting cases and important ones, including the Sabarimala case, the DK Basu judgment, which talks about custodial torture and death, the Jallikattu case, and through these, he gives the readers a sort of a ringside seat to a few rounds of arguments. He explains what was going on in his mind while he was arguing the cases and what was possibly going on in the minds of the judges who were hearing these cases. So it's a very interesting account, almost like a story of the life cycle of these cases, and I'm sure our readers will find it very, very beneficial for them. So congratulations on the book, firstly, Dr. Singhvi.
Thank you, Apurva.
And thank you for taking
I say straight away that the large part of the debt for this goes to Chiki Sarkar in terms of the conception. She came up with this idea, which I thought was something very simple and yet not really thought of and implemented, of having a book for the lay reader.
Absolutely.
And equally making it of interest to the lawyer. So you will find that basic spirit and thought process animates the entire book from the beginning. Of course, choosing 8 or 10 chapters alone or themes is like being forced to choose amongst your own children, because there are hundreds more, which is very difficult to be selective. But being forced to do that, the main USP of the book is that it's written really fully readable, understandable by the layman, the non-lawyer, but equally of interest to the lawyer, because it does deal with those complex questions or nuances which interest lawyers as well.
No, absolutely. That was my first observation of this book as well. And that, from what you just said, is my first question too. What was the selection process like for you to pick these few cases?
You see, as I said, it is as invidious as being asked to choose the best or the favorite amongst your children.
For sure.
But ultimately, since there are restrictions of space and time, we have to do this selection. And once it was decided to be 8 odd themes, then the obvious attempt by me was to include diversity along with importance and interest. So you have one case here, which is a human rights custodial death case.
Yes.
I'm talking of subject matter. Then there is a diversity of corporate law in terms of the Tata-Mistry case. Then there is a third angle about fundamental rights, the right to fly the flag, about the right to expression, things like that. That is the Naveen Jindal case. Then, of course, 2 and not 1 on the seminal set of rights called the right to religion under Articles 25 onwards till 30, which is, of course, here in this case, in this book, the Sabarimala case and the Santhara case. So this is, of course, a very important subject by itself, and therefore we've got 2 really themes on that. And then something again related to freedom of speech, but from a totally different angle, the Tata free speech, commercial free speech case. So, this is the diversity which was sought to be then injected into the book. And I think on the whole, it covers the more important broad subject headings of public law, which it should and was intended to do.
So there's something for everybody in this book, basically. And having read it, I can assure our viewers that that's the case. Now, Dr. Singhvi, while discussing the Sabarimala case, you wrote, and I quote, "It is very hard to change people's minds by passing judgments," unquote. And I feel like the courts oftentimes are passing well-intentioned judgments, but they're not really showing a lot of impact on ground. Take, for example, the Supreme Court's judgment on lynchings and mob violence. What do you think is at play here, and why is there this gap? And is this a similar sort of argument when we speak, when we ask the question, should the law reflect the society we live in or the society we aspire to live in?
See, this is a very detailed question in terms of an exposition. It could take a whole lecture by itself. But to make it short and simple, Sabarimala is a difficult case for the layman to understand.
Yeah.
It is also a case where I think my basic sentiment as a lawyer, don't judge your clients. Also, you don't choose your clients. I think it gives the great intellectual satisfaction of doing an unpopular cause, because the popular approach is, why and how the hell can you exclude women from a temple. The satisfaction and the interesting part of this case is that choosing an unpopular cause, I think we put our best foot forward in terms of the arguments, which can be as good as they can for an unpopular cause in terms of constitutional jurisprudence. So we've given very solid constitutional reasons why what might seem a one-sided position is not one-sided. Now, to your question about the court subjectivity, rights of religion under Article 25 onwards are the most classic example of that subjectivity. People tend inadvertently almost to impose their subjective beliefs. But for the last, 50, 60 odd years, court after court in the Supreme Court has warned you, saying that first and foremost, when you apply the essentiality test, the test whether a practice alleged to be infringing some right, is it an essential part of religion? That essentiality test must be applied with a broad subjective band. Yeah. It is not an objective external standard of Apurv being imposed on Singhvi. It is a subjective view of the adherents of that religious belief as to what they believe in. But that, you are absolutely right, is frequently forgotten. Now, in Sabarimala, just to be very quick, as I said, it's a very abstract subject. We were able to argue on 2 or 3 planks and we got 1 dissent in our favor. And then subsequently, we succeeded partly in the review because now it is open and reconsidered. Plank 1 was that this is not gender discrimination. I'm giving you our point of view, the one I argued, which is what is projected. Yes. I'm not saying it's right or wrong. That's it. Mm-hmm. It's not gender between men and women. It is actually a classification which is permitted under Article 14. So long as it is shown that the classification between black and white has a reasonable nexus to the object sought to be achieved. So how did we show that? In a seemingly impossible case. We said this is first and foremost a classification between women below 10 or above 50, along with men on one side, versus women in the menstruating band of 10 to 50. So that's not a simple woman versus men classification. Second, question is, does this classification have a reasonable nexus to the object sought to be achieved? To make it simple, we demonstrated that this Sabarimala deity is the only one out of 1,500 Kartikeya deities across India. 1,499 others are all Kartikeya in different forms. This is the only Naishtik Brahmacharya Kartikeya, the one who is called the eternal celibate. Point number 3. So on the one hand, you establish the classification between men and women on the same side, but below 10 and after 50, versus women between 10 to 50. Second, you establish that the connection is with a eternal celibate. Then comes the third one. This classification is clearly reasonable because it bears a direct nexus to the very object of the worship, which is to worship eternal celibacy, which is why menstruating women for a symbolic purpose are excluded. So it is not a mindless classification with no object or nexus. Women who want to worship Kartikeya are entitled to fully go to 1,499 other temples in India. Right. There is no reason to choose the one which celebrates Kartikeya in his eternal brahmacharya form, which must then necessarily allow women of an ovulating, menstruating period to also go to an eternal celibate, which is a contradiction. So this is the broad level. Of course, there are lots of sub-arguments. People pressed into, one judge out of the 4 has pressed into service 17, which is exclusion because of, other considerations. It was demonstrated and the other judges did not accept it. That 17 will not apply here because it is only caste-based exclusion there, which it So this is the intellectual satisfaction of doing a case like Sabarimala. Not the winning or losing of the result, but, having several such similar arguments.
I'm sure. Since we're talking about Sabarimala, the dissenting opinion also spoke a lot on PILs and a locus standi, and that's one of the questions also now pending in the review petition. Now, like I mentioned in the book also, you've spoken about the nature of PILs, generally public interest litigations, whether it's Sabarimala case or the Santhara case. Both were brought about by people who were not necessarily a part of the community, which was the subject matter of this case. Do you think there needs to be a fundamental change in how PILs are currently being entertained?
Absolutely. Absolutely. I argued that, and the book also, in a non-technical manner, attempts to demonstrate that. Yeah. But it's not going to happen in a hurry. unfortunately, the system is now entrenched in PILs. There is another facet of the PIL which is being forgotten in this. See, what happens in a PIL is, assume that one is PIL, one is locus. Now, I'm first going to deal with the PIL construct, the very nature, the structure of a PIL.
Sure.
PIL, assuming that Apurva has locus, I'm assuming, I'm not conceding. Even then, a PIL is by Apurva where the respondent is a person doing a religious practice. Otherwise, normally that respondent, that is Singhvi, who's asserting his Article 25 rights, would be a writ petitioner. So tomorrow, if somebody came and infringed my Article 25 rights, I would be able to go to court as a writ petitioner and run my case. Today, I have become a respondent because an outsider, Apurva, even assuming she is locus, has challenged something in a PIL where I can't assert my fundamental right to 25 in that affirmative sense.
Right.
Of course, I can as a respondent. That's one. Second is, we were able to show the locus part, which is the other part, that for every Apurva, there were, in the case of Sabarimala, 1,000 non-Apurvas, women organizations and women who supported the Sabarimala practice of not allowing women. I gave the example, I said, although it's not written in that clear a sense, but today, you will find mothers, sisters, wives, daughters, normally in a normal case, forget Sabarimala, hesitating and not going into temples during their menstruating periods.
You mentioned that in the book. Yes.
Now, there is no, I mean, if you find your family will force them, they will not go even there. This is a practice which is going on time immemorial in India. How can it be in the one case where the eternal celibacy is being celebrated, be a ground for a PIL to intrusively say, thou shalt enter, because it's discriminatory? Women are, practically speaking, in Sunni Islam, not allowed in mosques. Now, these are subjective customs and beliefs of that particular religion which you have to respect. I mean, I would say, no, look, I see no reason why rationally women can't enter a mosque. Or why should a menstruating woman not go into a Hindu temple? But that is not the way a religion is constructed. It's a very antithesis of a religious order to start asking these objective external questions as if you are a kind of a bull in a china shop.
And then there's this whole thing about the PIL, the judgments that are delivered through these PILs impacting lakhs or thousands of other
people. And again, thousands of parties. The entire world is bound. Whereas the persons who are directly affected are not necessarily at the forefront.
Who are not necessarily being able to put their stand forward. Now, moving on to another one of the cases that we discussed, it was the flag case. You mentioned how the center at several instances offered to amend the flag code, but the court instead chose to hear the case and decided on rights and merits. That was very interesting for me because then I started thinking about how petitions challenging Section 124A of the IPC, the sedition law. I want maybe you to tell us, what do you think about the course adopted by the Supreme Court in that case in allowing time for the government to re-examine the law while staying pending trials, appeals and proceedings?
Thank God that did not happen. Thank God that the government, though given a long rope, I think too long a rope by the Supreme Court, did not ultimately amend it. And thank God the same rope is not being given and according to me should not be given in sedition law either. I'll tell you why. Governments inherently given a chance will tweak the law a little bit, give a cosmetic change and say now everything is hunky-dory, you please uphold it. So you have a double whammy. You have actually a change which is not substantive, it's only cosmetic. And B, you have a legitimation effect of a court upholding it, saying, they went back and they're such good boys, they've come back with some good change. So you have a double whammy. In the case of the the right to fly the flag case, I was joking after retirement with Justice Khare. I said, I traveled with you from Court 6 to Court 1, where he started presiding. During the course of Court 6 to 1, frankly, he was very keen not to decide on many dates. Saying that, look, what does it matter, Dr. Singhvi? They will now amend. They are going to amend. They are saying they will amend. This law officer is saying so. This counter is saying so. Let's give them more time, which is why the journey from Court 6 to 1 took several years. It was mainly on these adjournments where the government would come and say, no, it's before this committee, it's before this cabinet, it's before this time, etc., etc. But ultimately, why do I say it's good it never happened? I say it's good it never happened because the court can then lay down rights clearly. And then the law has to conform to those rights, not the other way around. That the law is first, and I mean, the law is amended first in a cosmetic or a partial way, and then the court kind of skips the real issue. So therefore, when we argued it, now the judgment places this squarely on the right to expression. Right. My right to fly the flag on top of my house is my right to expression. Now, as you know, any law which in future you pass has to conform to all those parts of the law, of the judgment, which provide that you cannot derogate from my right to express myself by flying my flag. Right. Save and except, of course, public order, sovereign relations, whatever. Two more quick points on that. People tend to forget that. Our assertion of the right was always, and I use the word never, the right to fly the flag. The right to respectfully fly the flag. Right. So I have a right to fly the flag upside down. That is not the case. I have a right to fly the flag in a torn manner. That is not the case. Right to only respect. Second, simple examples have an effect. I started the case by saying, well, it's very strange. A Pakistani can fly my flag in Pakistan, or a Pakistani can fly my flag in India. An Indian can fly the Indian flag abroad. Right. But the Indian can't do it in India. And that struck a chord immediately. If I am able to fly my flag respectfully, then why the hell should I not? And then the other point which went home was that it is not that the fear of the government is real, or it is largely imaginary that, look, you'll tear the flag, you'll distort the flag, you'll decimate the flag. Because for all such disrespectful demonstrations, you have separate laws which punish you for imprisonment. There is a National Emblems Act. There is a national, what is called that, honors. You can't go and say anything you like about the President of India or the Prime Minister of India. So these are anyway protective safeguards. And these are excuses on which you are denying the right to respectfully fly the flag.
Right. My final question here. Now, in the conclusion to your book, you mentioned that the Supreme Court the past few years has shown reluctance to act against the government in matters where there are great stakes involved. We have, of course, seen several such cases, case files just gathering dust in the courts. And these are some very important cases involving constitutional questions. We always take the electoral bonds case as one of the examples. What do you think is the reason for this reluctance? And
it's sad. It's sad. No, there is no, there is, to be honest, no explanation. It is unjustifiable. It is indefensible. I'm saying it very bluntly.
Okay.
The only reason I can ascribe is avoiding the issue.
Okay.
Avoiding the issue is also understandable for a few weeks or a few months. Today, you have mentioned just now a phrase. What is the effect of this avoidance?
Yeah.
Electoral bonds have been published in government figures that 95% to 90% goes to one particular party, in this case, the ruling party.
Yeah.
I'm not saying it's right. I'm not saying it's wrong. Apurva has a right to give every money to X, Y, Z. But will somebody decide this issue? Now, 5 or 7 years have passed. Do you know the non-level playing field created by 90 out of 100 rupees going to you and not to me? And the figure is that all the other non-ruling parties put together, 7 times or 10 times more than that is one party. So now somebody has to decide this. If you have the upfront thing, decide it in the favor of the government of the day. But decide it at least. The same applies to the statehood bifurcation in Jammu and Kashmir. These are matters which cannot brook one day's delay. What is the big problem? What's the big deal? If the Constitution bench sits for hardly 2 or 3 months, they can decide many of these matters. There should be an exclusive Constitution bench for this. So I have no reason, no hesitation in saying it has more than anybody else heard the image of the Supreme Court.
Right.
You forget the government, forget me, forget you. They have to protect their own image. And people start ascribing motives, and that's not in the good health and the good interest of the Supreme Court.
No, that's right. With this, we've reached the end of this conversation. For our viewers, just to let you know, I'd like to emphasize on how simply this book is written. It tells a story of some very important cases that courts of the country have dealt with, while giving an insider's perspective on these cases as well. So it's a very fascinating read, and I'm sure many of you will appreciate it. Thank you for taking out the time and joining us, Dr. Singhvi.
Thank you.
Thank you.